In a time of rising unrest, when borders dominate headlines and immigration policy shapes the future of our nation, the truth matters. From the front lines of law enforcement, national security, and public policy, this is Frontline Facts, where rhetoric is stripped away, where politics takes a back seat, and where facts, hard, documented facts, lead the conversation. As instability grows beyond our southern border, as communities feel the impact at home, we bring you informed voices. Attorneys, senior law enforcement leaders, policy experts, and professionals who understand the law, the protocols, and the consequences. This isn't opinion. This isn't spin. This is clarity in a time of confusion. This is Frontline Facts, and the conversation starts now.
Welcome to Frontline Facts with Luisa Deason, where we correct the rhetoric on immigration issues and public policy. We're here today with a special guest who has firsthand knowledge and works with detainees that are in the process of being deported from this country. He's a busy professional, but more importantly, he is a certified and licensed immigration attorney through the federal courts. Please welcome our guest today, Ignacio Pinto-Leon. Welcome to the show, Ignacio. How are you?
Thank you, Lisa. Happy to be with you.
Listen, there's a lot of rumors and a lot of speculation and a lot of fear going on in many communities, but I'm so grateful that you're on the show with us today because I think it's important to start giving out what the law states today. Not whether or not it's going to change, not whether or not what it was like. It's what is the statute today? And I think it's going to maybe in hopes calm some of the fears in the community and clarify what people can and cannot do. So let me start out by asking you, I know that you've been a certified immigration attorney through the federal courts. How long have you been practicing law?
I have been practicing law. I was first licensed in Mexico since 2000, but after I moved here to the US, I have been practicing law as a licensed attorney in the United States since 2007.
And you're aligned with some of the best, so you come well recommended, by the way. And of course, with my background, having worked for both INS and ICE, I know benefits and I know enforcement sides of the statutes. But I think that the conversation you and I had earlier this last week prompted me to want to have you on the show to clarify a bunch of misconceptions and just to diffuse rumors, just because we really need to know and understand the statutes, whether people like them or not. I mean, I'm never going to have somebody like me completely or hate me completely. It's just that immigration law is about as complex as tax statutes, and we're here to correct the rhetoric today.
And sometimes our job is to give not the answer that people necessarily want to hear, but what they need, the information they need to have to make their best decisions possible given the circumstances.
Well, and I think you hit the nail on the head. One of the things that I'm so concerned about is people will call me all the time and they'll tell me somebody spent $20,000 paying a lawyer and now they can't even represent them in court while they're going through deportation proceedings. And that's my biggest red flag is we need to get the word out that you need to make sure you're going to the right individuals and the right professionals in law, in immigration courts, because not everyone can represent you. And you are just that. You are certified. You've gone through the proper process to be able to represent clients that are detainees and to also be able to provide the added benefits to immigration laws that people can merit to either adjust their status to that of legal permanent residence and citizenship. Is that correct?
That is correct. And I will say the assistance that a lawyer can provide can be preventive or corrective. It is very important that when possible to try to get that legal advice well ahead of even trying any process with immigration authorities to make sure that to know what to expect with those processes. Sometimes we hear of people that you just mentioned that spend tons of money, but with fact pattern that probably didn't want it to even start one case. So it is very important to get advice from licensed attorneys to have the knowledge on where to put your money and your hopes.
Exactly. I couldn't agree with you more. I'm going to go ahead and just start asking you a few questions. They're always asking me. So the first one is, I understand Title 8, Section 1325 I understand Section 1324 and 1326 very, very well, having worked for ICE myself. But a lot of people believe that there is a blurred line and that entering this country illegally is not a crime. What can you say to that individual that really truly believes it's not a crime?
There are different types of crimes. Some are felonies, some are misdemeanors, and but there is also a process to any country has to regulate the means of entry of any foreign citizen, and the United States is not the exception.
I agree with you. Now, what is the first thing that happens, or what is the first thing that you recommend someone do if they are detained by immigration and customs enforcement?
If that situation happens, the first good news that they have is that there is a legal process, that there is rule of law in this country, and that they are not going to be in personal danger, which is not the case in all countries. And that, yes, if they are in custody, they are going to go through a process and they are going to have a chance to communicate with their families, and that eventually they will have uh, access to legal representation. Now, it's important to know that this access does not happen immediately. Sometimes it takes 1, 2 days. In some instances, can take even more than 2 days. But eventually, you will have access to a lawyer.
Well, then, in many cases, correct me if I'm wrong, Ignacio, but are they not entitled to, depending on the country, there are also binational agreements that need to be upheld so that the U.S. makes sure that they're not violating people's Geneva Convention Act and or other statutes. That's always been my understanding.
And also, I mentioned before, and this may be a given for a U.S. citizen, but in several countries, if you're detained by the authority, you are in personal danger that they will either commit crimes against you or extort you. That is not going to be the case in the United States. Yes, it's unfortunate if you are deprived of your personal freedom, but you should be generally safe. So, as I said, this is not a minor thing for as compared to to different countries.
Well, and I know that it's a misdemeanor the first time you're apprehended and then a felony thereafter, or if you have a final order of deportation, that certainly changes the dynamics. Now, give me an idea of what are the first calls that come into you? What kind of cases are you covering and what do you see?
Typical call will be a somebody calling saying that a family member was detained while going to work because they were stopped by the police. They were not able to demonstrate their legal status. They were ICE was calling and they are being transported and detained to be processed by the immigration court. That is the typical case. Most of those calls, the clients either do not have a criminal record or have some minor record, but in recent months, those detentions seem to be unrelated to a criminal activity, but most cases they're conducted on traffic stops. That's what I've been seeing the last year and a half.
Well, and what I've always said is try not drawing attention to yourself, but therefore afterwards, if there isn't any recourse for a benefit, I'm getting a lot of calls with people that have been here maybe 20 or 30 years, and in that time frame, they've never taken the time to see if they can gain a benefit or done anything about resolving their situation. What recommendations do you make to people that are in that kind of a situation today?
As you mentioned, not to call the attention of authorities even when driving, because driving in Houston is a necessity. And of course, people without legal status generally don't have access to have a driver's license. Uh, I understand people have to work, people have to provide for their families. So it's a necessity of drive. With or without a driver's license, that's a reality. But they need to be super cautious on following the traffic rules and keep an eye on the speed limit. And we have to behave better than the locals. There is an extra necessity because the uh, calling the attention of the police may have great consequences for them. That is one thing that I always recommend. And if you have or think that you may have a path to get any legal status, always consult with a licensed attorney. And of course, I have an incentive to have consultations because I charge for that. But there are free avenues for legal advice as well. Most of our Latin American consulates have lawyer volunteers that provide free legal advice. So I will encourage people to consult with lawyer preventively, proactively to see if they qualify for any avenue to obtain a legal status in this country.
Well, and you made a valid point. Oftentimes people ask me who they should call, and I say the first person you should contact is your consulate. That's why they're here. That's why there's representatives from all kinds of different countries here, whether it's an embassy in Washington or whether it's a consulate here. But you need to have those information and that access because they're here to help you and guide you as well. Now, to the person who says, okay, been detained, will I be able to give a call? Can I call my boss? Can I tell him I've been detained? Who do I call first? A lot of questions are, how can I get a hold of somebody if somebody is being processed? Like you said earlier, sometimes it takes a couple of days to be processed into the system, into that detention center, or maybe because of bed restraints or, conflicts of jurisdictions or areas that may not have the adequate care for someone in need of some kind of medical attention. They need to be transferred elsewhere. What kind of recourse do people have that have been detained that are in those kinds of situations?
In most cases, Luisa, the authorities give the same is a free 5-minute call. So the best usage of that call is to call a family member, call the mother, father's, the spouse, the son, daughter, and as soon as they assign aliens and the alien number, the
Right.
agency number, which is a 9-digit number, it is very important. The first thing that they should share is, I am okay, I am in this place or are going to be transported to this place, and this is my alien or agency number. That number will identify that person's case all over, all over. So, and that's basically what they are going to be able to share at that moment. And again, they should know that help can be on the way, on its way, but it will take uh, a few hours or days to get that access, and that's fine because generally speaking, unless the person has a final removal order or they are going to be subject to expedite removal, generally anything that happens is going to take weeks or even months to go through the courts.
You're right, and it also depends on the country of origin and where they're going. Sometimes flights, if someone has a final order, the flights to say somewhere that's, not neighboring countries such as Mexico or maybe Central America or Canada are going to be a lot more difficult than trying to obtain travel documents. Those flights don't always leave on the same day, or they don't have multiple flights a day, or maybe not. Maybe they have a few selected types of flights a week. So that all goes into coordination with what the government has to do. Now, what do you recommend when people say, well, the government's stating that somebody should, go ahead and self-deport, leave under your own recognizance, and that way it won't ding you. What can you tell people about that process?
And are we speaking about somebody who is detained or
Someone who's
just
detained,
generally?
well, detained and doesn't really have any serious crimes committed other than maybe an illegal entry, which is still a violation of Title 8, Section 1325.
If they are detained, I would think it depends on whether or not they have any hopes to obtain immigration relief from the immigration judge and whether or not they will probably qualify for a bond. Normally, if they do and they have the means of paying for that bond or paying for legal representation, if they have a decent case, normally they will make the investment to fight for that case. If they don't have any case at all and they know that in advance, then a lot of people will choose just to leave the US just to avoid continue being detained. But that is a personal decision. And in a lot of cases, it is a good idea to wait to have a consultation with a lawyer to have a good understanding of the real chances that they have.
Right. Now, obviously, somebody with a final order is not going to have those same opportunities awarded to them. The final order means they've either, absconded and didn't leave when they asked to leave voluntarily and they failed to do so, or they've committed crimes that have rendered them deportable and can no longer stay here. With a final order, it's an immigration court that makes that decision. It isn't a southern state district court that makes that decision. Explain that a little bit so our audience can understand that.
And I will add there is one extra possibility. The person may have an order of removal and not even be aware of that. Sometimes they are not notified of those orders. But generally speaking, I agree. If the government's position or the law's position is, generally speaking, if they had their day in court and lost, then that's when they had their chance to fight the case. There are some exceptional circumstances where they may have post removal order relief, but generally speaking, I agree. Once they have a removal order, generally is that's the end of the road.
Well, and they can ban them for being here. What we're trying to avoid is the excess of those individuals that have committed crimes in this country that are use the United States as a revolving door. Those that have multiple, deportations and then have committed crimes both in their country of origin and then they come here and commit crimes as well. And what I'm referring to is the dangers with cartels and, of course, narco terrorists and things of that nature. That's not an option. But my heart does go out to people that have just sought out an opportunity in this country, but there are laws to be followed. What can you say to those that say that, ICE is fascist and that they're Nazis and that they're, what has been your experience when you have dealt with ICE agents on specific cases? And maybe give me an example of, I know some of them have been the most professional people I've ever worked with, but you're a lawyer, you see it from the other side. Maybe you can describe what you've seen in the past.
My general experience is that they are professionals. They have an important job, and right now they are under, for what I see, like an extraordinary amount of pressure. We only the most evident part of this of the government's offensive on immigration is on the aliens and their families, and that is fine. But I also appreciate the pressure that everybody within the system is, including judges, ICE agents, and as I said, they have new levels of pressure right now. So I, for one, appreciate the job that they do.
Well, and I worked alongside of many of them for many years and have remained friends with many of them. And I just think, they are very professional. You're always going to have somebody here and there that might be a bad apple or maybe there's lacking in training. But, we're very fortunate in that we haven't seen here in Houston what you saw in New York and what you've seen in Minnesota. And for that, we're very fortunate. But give me your understanding and why you either believe or don't believe in that 287G program. Maybe describe it to our audience. What exactly is that, and how do you see that benefiting or maybe posing a challenge to the immigrant community?
Those are agreements that can be between local policies and federal immigration authorities, cooperation agreements. It's an administrative tool that the government has, and I don't have much of an opinion on that.
But sometimes I'm posed the question as to why I support it, and I say, well, it'd be no different than arrangements between other police departments in different states. If you're looking for a murderer or a rapist, or someone that's just a hardcore criminal, why would you not extend courtesies to expand that and be able to communicate to get people that pose a significant risk to communities, that ability to communicate effectively with other law enforcement, whether it's local, state, and federal. And oftentimes the people caught up in that trap are going to be people that don't have serious violations, but that law has to run across the board towards everybody. Is that not fair, or do you see that differently?
Again, that's within the police department and the federal government. I don't have a strong position on that.
Okay.
It goes beyond. I see that's going mainly beyond the scope of my job.
Yes. Listen, we're going to have to cut over to a commercial break real quick because we do have sponsors we want to highlight. Thank you for waiting.
Houston, we have a problem. We live in a time when headlines move faster than facts, when stories are shared around the world in seconds, and when truth often becomes lost in the noise. But what if you could step behind the curtain and see how the news is really made? In a reporter's journey inside media, DHS and ICE, veteran journalist and former DHS and ICE spokesperson Luisa Deason, takes readers on a remarkable journey from the newsroom to the front lines of government communication. For decades, she witnessed how stories were gathered, shaped, framed, and delivered to the public. She saw the pressure of deadlines, the competition for ratings, the rise of 24-hour news cycles, and the growing influence of narratives over facts. This is not a political book. It is a book about understanding how information reaches us, how public opinion is formed, and why critical thinking has never been more important. If you've ever questioned the headlines, wondered what's missing from the story, or searched for the truth beneath the surface, this book is for you. A reporter's journey inside media, DHS and ICE, from the newsroom to DHS and ICE. I saw the truth before it was changed. Coming soon to Amazon.
Well, we are back. I am Luisa Deason. I'm your host for Frontline Facts. We are correcting the rhetoric, and we're coming back to our guest today. Okay. If people are deported, what are the chances, or what kind of things can they do once they're removed? Depending on how they've removed, can they come back under a different visa? And I'll give you an example. I get a lot of B1, B2 visa callers that call me, and they're either apprehended or the spouse is apprehended, but they never adjusted their status. And so now they want to say, I want to leave the country voluntarily. I didn't have any prior crimes other than my violation of Title 8, Section 1325. Can I come back under a different visa? Can I come back as maybe a fiance visa, or can I come back, we're looking for an employment, or can I come back as an investor? What are some of the things people can do?
The first step, with or without the removal, figure out if there is a path to obtain a visa, like a non-immigrant visa or temporary visa, or an immigrant visa or more permanent visa. So the first challenge is to figure out if there is such a path or way. If there is one path, and for some reason that was not exercised while the person was in the US, then we have to consider if there are any roadblocks to that path. Let's say somebody is married to a permanent resident. A permanent resident can initiate a family petition for their spouses. And let's imagine that person was removed to Mexico or left voluntarily. Once they are in Mexico, we know that they have a path to eventually become permanent residents through a family petition. So that is the avenue, right? But let's say that foreigner he came here with a B1, B2 visa, but he overstayed his authorized period of stay for 10 months. And they return on their own to, let's say, Mexico. They do have one avenue to become permanent resident if their permanent resident spouse initiates a family petition for them. But there is going to be one roadblock, and that roadblock will be that they overstayed 10 months. They were unlawfully present in the US for 10 months, and they left. There is a rule that says that if you are in such a situation, you cannot come back or obtain a visa for 3 years. So that is one roadblock, for example. So the ability to return to that person will depend on that particular roadblock and whether or not they can do away with that.
So where does the 10-year ban apply?
Key concept is days of unlawful presence. And once the person has accumulated 1 year or more days of unlawful presence and departs the US, whether on their own with voluntary departure or deported, if they leave, they cannot come back for 10 years. So the difference
Okay.
between the 3 or 10 is the number of days of unlawful presence. Now, there are two ways of making that roadblock disappear. Wait 3 years or 10 years, or apply for a waiver of inadmissibility and have it approved. So that in that example, that will make the difference whether or not that person can come back to the U.S. legally soon or not. But let's talk about another option: applying for a B1 B2 visa after being removed from the country, uh, assuming that they don't have the 3 years or 10 years ban for unlawful presence. It's going to be very difficult to have that B1, B2 visa approved because of the derogatory information on their file, right? If somebody overstayed 10 months and was sent to an immigration court and then applied for voluntary departure, the consul in the US, in Mexico, or in any other country, the US consul already knows that that person overstayed or came here illegally or whatever. So it's going to be very hard that they approve a B1, B2 visa because of the uh, fear that that person will again overstay in the US. So
Well, and is the threshold statute-wise, isn't it 180 days? If you're here either working or here under those kinds of visas, if you're here in excess of 180 days, is that not something that also can be count against you?
if you overstay, or if you're here unlawfully present between 180 days and less than a year and you depart, you have a 3-year ban. And if you overstay a year or more and you depart, then it's 10 years. But even if you just overstay 150 days, that can be taken into account when they are deciding a B1, B2 visa, right? The legal presumption is that any applicant for visa, for a non-immigrant visa, or any applicant for admission at the port of entry with a non-immigrant visa has the intention of staying in the US. And the burden of proof, the duty to demonstrate otherwise, is on the alien. So the starting point, the legal starting point, is one of distrust. And that is why the government really doesn't have to give much explanation when they deny visas or when deny entry to somebody. Technically, it's only the foreigner not convincing the government that their stay is going to be for the purpose of the visa only.
And Ignacio, you bring a very valid point because, again, the Department of State is the entity that issues the visas, but yet they can come in and an inspector, an immigration inspector or CBP inspector at the port of entry, whether it's land, maritime, or whether it's air, can always deny that entry based on the facts of the questions they ask. And if they feel uncertain that the person has intentions of coming into work and not leave, then obviously those play a great factor in the declination of that document.
That is correct. And some people have this B1, B2 visa, and they have come 40 times in 15 years. Each and every time that they come to the US and they present their visa, they're applying for admission. And technically, each time the government makes an independent decision whether or not to admit them. So when they deny entry to somebody, it's just that on that particular occasion, they are deciding not to admit him or her.
Right. Now, let's talk about some of the things that you see, or maybe you have noticed that there's some fraudulent activity going on. I've seen a lot of it through business petitions that entitle, opening up several sub companies, and then you really don't know who the originator is, but there are restrictions to an employment based petition. Can you describe what that looks like? Let's just describe the legal process of what that looks like. I know the paperwork that needs to be put forward, but do you see or do you work on any of those types of visas where you have people coming in for the purpose of business to either work for a company that has hired them or to become investors and bring their business to the United States?
I don't do business immigration, but I can tell this: fraud is disgrace, and it puts the country in danger. But it also puts an extra burden on authentic cases, real couples. For example, in family based, as I explain my clients, not only in family-based cases, all cases really, your case is competing with another that looks just as good as yours or even better. That is false. So the government is going to be distrustful of your case in part because of that other person's decision to lie. So it is a problem. And again, the system has safeguards, like authentic cases suffer because of that need to double check that we're including fraud. So that's what I can share.
I would agree with that. I think that a lot of people maybe brush with the same brush, but it's almost well, it's following patterns of behaviors, and so similar things may mimic each other and look alike. But I know, having worked for even the benefit side of the house, that really no two cases are alike. They're all going to have their own individual entities and challenges, et cetera, et cetera. And people that might have petitioned for somebody during the same time frame don't understand that why is mine approved and his isn't, those kinds of situations. But let's move into some of the stuff that I've been hearing a lot about. Maybe you can give me your perspective on it. I hear a lot of these people that are being told by people that are not legitimate attorneys to file. They're asking the parents to file lawsuits or file abuse charges against the parents in hopes of some kind of reprieve for the parent. Have you heard of that, or have you seen any of that?
And that is an abuse of a very generous law, VAWA, the Violence Against Women Act, that includes some provision that protect uh, victims of extreme abuse perpetrated by U.S. citizen or lawful permanent resident members. This case was originally created by Congress to protect mainly women from abusive spouses, but it is gender neutral. And I have had some authentic cases of spouses that obtain relief through this mechanism. But in recent years, the law has always allowed for the possibility of obtaining relief if the abuse came or was originated by the U.S. citizen or lawful permanent resident son or daughter, which are less frequent. But in recent years, I saw an increase of uh, people seeking this avenue to a number that make it suspicious to me. That, I mean, they cannot be suddenly so many as abusive kids, right? The previous administrations put a pause on these cases to to review, and it has come to light that indeed there have been some abuse apparently by some specific law firms and non lawyers too.
Well, and you know that there's a lot of unscrupulous attorneys out there that take a lot of money up front and then they don't really do anything, knowing well that during the initial consultation, that person doesn't stand a chance of staying. And I think those kinds of repercussions really wreak havoc on a family. But the other thing is, are there any consequences to the lawyers that are just milking money out of people and taking advantage of the immigrant community that is so vulnerable today? What can be done? How can those people be reported? What can people do?
There is an option, and all lawyers, we are licensed by a specific or specific state bar associations, and we respond not only to the client but also in on our ethical duties. We respond to the bar association. That is one of the avenues. The attorney generals also have some units specialized in this type of cases, and that, by the way, includes abuse by notarios, notary publics that are non-lawyers. different to our Latin American countries. You don't need to be a lawyer to be a notario público. That is the main remedy. And I will add that we should distinguish in between lawyers that are aggressive in their hiring practices, where they take risky cases and they may or may not disclose the real possibilities to their clients. Uh, we should distinguish those from open fraud cases. In the case of these VAWA cases, where they allege abuse by the children, I mean, they cannot possibly be that high of a number of abusive children. That is, if the facts that they are presented are false, then that's a different question, right?
Yeah, that's crazy. I mean, to think that those are on the rise. You know, we've seen a lot of abuse with some of the H-1B visas as well, um, coming out of India. You know, of all places, we live in a country where the people that come in under those kinds of business-based petitions are highly skilled professionals. And in my opinion, at some point there has to be some kind of a reform and maybe visa creations that the Department of State can take a look at and consider, but that really allow the person who's been here or that has not done any harm to the country and simply wants to come in and work and benefit. And I know that they send a lot of money back, but I mean, there's got to be a visa category that kind of allows certain labored or trade workers that are skilled to be able to participate in something like that, as well as not just the highly paid professionals that are gurus in their field. And I've always been a big proponent of that. Just look at the Days of the Bracero programs and how these agricultural workers that came in 20, 30, maybe 50 years ago took advantage of a program that allowed them to stay. And now we have, second, third, fourth, and fifth generation Mexican Americans here or from other countries. But where do you think we need to go from here, and what we can do to help people that really do merit being here, and how can people get a hold of you?
Lisa, again, thanks for this opportunity to be sharing this time with you. I will say I think most people would admit that there is a divergence between the legislation, the rules, and reality, and that the unauthorized workers are part of the economy, and whether we want it or not, they are needed here. That is a reality. And a lot of them have been here for years and years, and they have their families, and most of them have not committed crimes. A lot of them are taxpayers, and there are certain industries that really depend on this labor, and just getting rid of everybody is not realistic. And this is a country of laws, and that contradiction between laws and reality has to be resolved. In my opinion, what we need is a comprehensive immigration reform. The last major that we had occurred in 1986 with a Republican president, with a Republican Congress. So hopefully, Congress doesn't seem very likely right now, but Congress will find a way to create a comprehensive immigration reform with the filters that need to be contained and with the rules that are warranted, but that they will create a solution, a workable solution for this uh, discrepancy in between law and reality.
Right. I agree. And I think that it's also very important that people recognize that ICE doesn't write the laws. They're following the laws that Congress has written and that have been approved, that are statutes. And these statutes have been on the books for at least 35 or 40 years. Many of them have, unless there's an executive order written. Now, how can people reach your office, Ignacio?
Thank you. They can search my name, Ignacio Pinto-Leon. We have a website as well, pintoleon.com. Our phone number is 713-338-2879, and we are also on social media. But the most important thing is to really take this seriously, and if possible, go ahead and have a consultation and visualize what options you have well ahead as a preventive strategy and not corrective.
Well, I can't thank you enough. Again, we've come to the end of our show today, Frontline Facts with Luisa Deason. I am your host, and I really want to thank you, Ignacio Pinto-Leon, for your time today and for the clarifications that there's so much confusion that's been created that I hope in sharing this episode, we will be able to kind of calm some of the um, fears and the rumors that we hear today. I would love to invite you to go back to the show at some point in time, give us other updates on what your progress has been. But for today, I want to thank you and I want to thank our audience for participating in today's episode.
Thank you, Luisa. It was my pleasure, and look forward to continue this conversation.